Imagine this. You met an immigrant whom you fell in love with, and that person lives here in the United States. You married that person. You have decided to file, or you've already filed, an I-130 petition, the first set of paperwork that starts a green card marriage person, because you want to secure that person's future in the United States. But you ran into an unanticipated roadblock, a roadblock that stems back to actions from several years ago. You're confused, rightfully so. Friends, family members, notarios, or maybe a lawyer told you that the green card marriage process was perhaps the simplest way for a person to obtain permanent residency in this country. And generally speaking, they're right. That doesn't mean, however, that there's no roadblocks, that there's no problems in the process. In this presentation, I want to share three devastating incidents that I've seen occur with married couples based off the I-130 that put their lives together in jeopardy. Problems that first caused an immigrant to have to file a waiver because that immigrant now has to return to their home country. And without the waiver, they wouldn't be allowed to lawfully return to the United States. Problems that cause immigrants to be referred to immigration court, where they're going to face deportation charges because of their unlawful presence in the United States. And if they don't prevail, then they're going to be sent back home. Or problems that force the immigrants to address charges based of fraud or marriage sham due to a previous relationship. These problems, I'll note, are not commonplace, but I've seen them enough that when they occur, they are so devastating that I wanted to share this video to make you aware of them, so that as you go through this marriage green card process, you don't face these same problems. So let's dive in. Providing inaccurate information in an I-130 petition is one of the biggest blunders that can possibly be avoided in a green card marriage case. For instance, take a couple that visited me a few months ago. The husband had filed an I-130 for his wife. They had assumed, because they had been told, that the mother's petition for his wife, when his wife was younger, would be able to put them in a position that the husband could immigrate the wife and she could remain here in the United States throughout the process. However, they didn't have the records to back it up. So we had to obtain the records from the government. What was discovered in the paperwork was that the petition that had been filed by the mother was backwards. It stated that the daughter was the petitioner and that the mother was the beneficiary. It was backwards. It should have been the other way around. And so, because the petition was for the mother, the husband and wife now could not rely on it. And because they couldn't rely on it, her only option in terms of becoming a permanent resident was to go back to her home country for an interview. To do that, because she had been in this country for so long, she would need to file an I-601 waiver, a waiver based on extreme hardship to the husband, a difficult task at best. This was an example of inaccurate information being prepared on the I-130, but it's also an example of careless preparation and the fact that since they had gone to someone else that helped them with it, never double checking what had been filed on their behalf. And the results were devastating because now the wife had to win a waiver. And without that, she and her husband faced the possibility that they might not be able to have a life forever after here in the United States. I-130 petitions often fail because of insufficient evidence. Take James and Julia. They came to my office after Julia had been placed in immigration court proceedings. James had filed a petition for her. Because he was a U.S. citizen, he assumed that all would be well. That's what he had been told by friends and family members. So, being a relatively educated person, he decided not to seek legal counsel and he proceeded forward on his own. However, he did not present a certified divorce document. Now, this is the type of I-130 problem that occurs rather more often than some of the other I-130 problems that happen in an immigration case. He and his first wife had a hostile ending. So even though she had filed for the divorce petition, he was so angry that he just would tear up everything as he received it. He did not contest the divorce. They had no children. And so he didn't keep any records. So when he married his second wife, the immigrant wife, about 11 years later, he assumed that merely stating he had been divorced and giving a general date was sufficient. No, the government wants an accurate description of the divorce. They want a certified document showing that the divorce, in fact, had taken place. However, he didn't have that. And in fact, he didn't keep contact with his ex-wife ever. It was a hostile divorce. And as a result, he couldn't find her. He didn't have any records. So with his wife Julia now in immigration court proceedings, he couldn't even convince the judge that their marriage, James and Julia, was valid because he couldn't show proof of his divorce in his first marriage. As a result, Julia faced removal charges, and they couldn't seek a defense based on the marriage or even a defense based on cancellation removal, which is based on hardship to a qualifying relative, which would have been James, because he had no divorce argument and he couldn't prove they were lawfully married. This is the type of insufficient evidence scenario that can destroy a valid, loving relationship. And it's not just James and Julia. This is one of those problems that I have seen rear its ugly head time and time again. And again, it relates back to something else: careless preparation. I-130 cases involving hasty withdrawals are some of the saddest situations I've ever seen. Sometimes couples go forward. The husband or the wife is trying to immigrate the immigrant spouse. And either before or after the I-130 is granted, they have problems. They have marital discord. They decide to separate. Perhaps they divorce. At the end of the separation or the divorce, the U.S. citizen spouse sends a letter to the government, to USCIS, confirming that they no longer want to sponsor. They no longer want to petition the immigrant spouse. And oftentimes they add details. And those details cause the government to suspect that, well, maybe this really wasn't a legitimate marriage. Sounds to me like it could be an immigration fraud. It could be a marriage sham. And that's put into the immigrant's file. Years later, when the immigrant meets someone else and they fall in love, and they're thinking about marriage, and then they get married and they file a new I-130 petition, that letter becomes a major roadblock to their success in the new relationship. I've even seen this occur in situations where the husband and wife reconcile, and maybe they reconcile even after a separation. For instance, the husband and the wife get angry and they decide to go their own way. They continue talking, but during that interim period, the U.S. citizen spouse files the nasty, hasty withdrawal with the government. They start talking again, maybe 12 months later, 18 months later, 24 months later, they decide to come back together as a couple. They can't go forward. They have to start over again because that hasty withdrawal has caused them problems. Because the government has terminated, revoked the I-130 petition. So they have to begin again. And worse, in some of those situations, the immigrant spouse and the husband or wife has to now prove in convincing terms that their first marriage or that their only marriage was legitimate, valid, authentic. And if they don't, then they're going to be facing charges of immigration fraud, marriage sham. And where that really becomes crucial is a second marriage to a different person. Those become very hard to overcome. And as a result, the immigrant spouse and either the second husband or the first husband that's reconciled have problems with immigration, problems that might prevent them from not being together. These are situations, again, that can be avoided, but they are not. And problems arise. And that in such situations, they can destroy the dreams and hopes of a couple living together happily ever after in the United States. What do these situations have in common? Carelessness, plain and simple. As I noted at the outset, many clients assume the marriage, immigration, green card process is a relatively simple process. And the first step in that process, filing the I-130, is the simplest step that one can take because the document is relatively simple. However, because a document seems simple and the information requested seems basic, it doesn't mean that there's no pitfalls. And so clients proceeding forward on their own without seeking any information often walk themselves into a pothole and serious problems. In law school, I was taught that only a fool has himself for a client. Even a lawyer schooled in the law that represents himself is foolish. And if a lawyer representing himself is foolish, then imagine someone that's not trained in the law representing themselves or obtaining assistance from another person not schooled in the law. So I encourage you to take the I-130 process seriously, to take the marriage green card process seriously. Save yourself the potential of any problems. Save yourself the opportunity to live your life in the United States with the love of your life forever after by being careful and cautious and at least seeking initial advice before you proceed forward. Take care and good luck. I wish you the best on your journey to marital bliss and immigration happiness in the United States. Thanks for watching. Know someone who might be interested in this video? Then please take a moment to like and share it with them. Also, if you would like more videos on immigration, just click on the subscribe button. And here's a little bonus, a short guide that you can download for free by clicking on the link on the description box or the square-shaped image. Plus, if you have ideas for videos you'd like to see, write a short comment below or feel free to contact me at carlos@VitaraImmigrationLaw.com. My name is Carlos Vitara. I appreciate your time and hopefully we'll be talking again very, very soon.